First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Good morning and welcome to the first DCA. We have two arguments on our calendar this morning. We'll take them in the order in which they are noticed. The first case, case number 24-2352, Tri-City Electrical Contractors versus Robert Gondek. Ms. Sills, when you're ready.
May it please the court, Eleanor Sills on behalf of Tri-City Electrical Contractors and Amerisure, the EC in this case. I would like to reserve 5 minutes for rebuttal.
Noted, thanks.
I would like to start with issue 2 in this case. I have a lot of ground to cover this morning, and so I would like to go ahead and jump into something that's a little less factually intensive. So as for issue 2, the JCC erred when he awarded attendant care because Dr. Shea's IME report was not a prescription. In addition, there are two other problems with the award of attendant care, but the first is dispositive as to whether the attendant care should even be awarded.
Does it make a difference that the potential of the IME wasn't even authorized since there wasn't a dispute before the IME was hired, I guess?
Your Honor, I don't think it necessarily makes a difference in regards to whether it's a prescription, but I think that that is something that certainly plays into this case. Do you know what
I mean, is the way I read the record, and correct me if I'm wrong, the dispute was actually the claimant's dispute with his authorized doctor and his failure to prescribe attendant care. So he went to get an IME, I guess like a second opinion, and I don't see that authorized in the statute.
Your Honor, and I think that that's correct. Dr. Ramirez is the doctor who said if I was to prescribe attendant care, I would have, and that just I didn't find it necessary at the time. And that was September of 2022,
right.
And Dr. Shea did his IME report in 2023. So I would say the dispute was also a bit later, if there was a dispute at all.
But then at the same time, could any doctor prescribe attendant care, or does it have to be an authorized physician?
Your Honor, I think the text, the context in this court's case law specifically speaks to that an IME doctor cannot be medical treatment. And if you look at the statute, it requires the attendant care to be awarded at the discretion and control of a physician. If an IME doctor is only seeing the claimant once, I don't see how it can be in the direction and control of that IME doctor.
Sure, but imagine, like, instead of calling it an IME, let's say he didn't like his authorized physician and what he had to say, so he goes and freelances and gets his own doctor. Not calling an IME, just gets another doctor, and that doctor looks at him and says, and prescribes, if you want to call it that, prescribes attendant care. Would that have been good enough? Or does it have to be an authorized physician, authorized by the carrier, the servicing agent?
I would say that it needed to be an authorized caregiver in that regard. I don't think that we can doctor shop.
But the direction and control would exist there. If you go out and find a doctor and the doctor prescribes it and you're the patient of that doctor, then
Sure.
It seems like you have that element, which is an element here that seems like it might not be there.
And I think that that would be fair, and I think that the facts of this case do present a different scenario as we're discussing this morning.
What guides should guide our interpretation of what the statutory reference to a written prescription should mean?
Well,
What is a prescription, and
Sure.
what does that look like? Is it standard, or can it be anything that's written down?
I don't think it could be anything that's written down, and I think that it's interesting that we see in the record there are these forms that would be written on by an authorized treating doctor, and you can check attendant care, and I think it's I can't remember the name of the form, but it's in the record, and this was actually in response to a question within Dr. Shea's IME report. And so I think that is also makes it different than what a prescription might look like. And so I would submit that that's just not the same as what a prescription typically is, and I think that we look at the statutory text, we look at the context, and of course looking at this court's case law as to whether an IME is even a treater, I think that that also plays into it. And, you know, we can look at dictionary definitions, sure, but we also need to look at the context as a whole. And
Would it be fair to look at Chapter 465, which deals with regulation of pharmacies? And not surprisingly, in the regulation of pharmacies, there's a pretty detailed definition of prescription that would seem to support your argument. Would that be a fair thing to look at in trying to discern what the legislature meant for prescription in 440?
Absolutely, Your Honor. I think that is also taking into context, statutory provisions that would play in this regard. So on the attendant care, I think that that's dispositive of the whole entire issue. And I just think that the definition of an IME doctor who is supposed to be an independent evaluator, while maybe that's not always the case, or maybe we have competing IMEs, that again is, different here. And I think that the text and the context show that a prescription, or Dr. Shea's IME report in this case was not a prescription. Now, there are two other problems that I just want to briefly address, should this court disagree and find that it is a prescription. The retroactive award of the $12 an hour award that was given to Mrs. Gondek went back to March of 2020. And I think, again, the text of the statute shows that you can't prescribe retroactive attendant care, but I also think that because the EC is not responsible for the care until the prescription is actually presented, and here the JCC awarded attendant care from January 3rd, 2024 continuing, we should not take a snapshot in time of 3.5 years back as to what the non-skilled caregiver, or the family member in this case, Mrs. Gondek, would be making at the time. And I think that the JCC erred and by retroactively looking back in that regard. And in addition, the award, failed to meet the statutory requirements of the quantity, quality, and duration of the care, because that's just not specified at all, not only in Dr. Shea's IME report, but also the JCC's final compensation award. Now, turning to issue 1, which is the misrepresentation defense, the JCC erred because he failed to recognize that Mr. Gondek made misrepresentations, and then he instead looked at a subjective component of the testimony that was given. And he looked at, instead of first looking at that first objective evaluation, under Cal-Maine, this court's case, it's a two-pronged test. And the first prong I would submit to this court is an objective evaluation of if there was a misrepresentation. The second prong is a subjective evaluation as to whether there was the requisite intent under the statute.
The hypertension claim that might seem to be relevant in the alleged misrepresentation on that. The ED meds and the anxiety, though, since there wasn't a claim for that, why does that have any materiality here such that it would be a misrepresentation?
Yes, Your Honor. Under this court's case law, specifically citrus pest control, a claimant's relevant medical history is important here, right? And that's especially true where he was treating with a psychologist, Dr. Cubano, so his anxiety, and Dr. Cubano actually specifically opined that because there were no prior, incidences of depression or anxiety or things like that, he included that in his analysis. So I think the anxiety plays into that. As for the erectile dysfunction medication, now Dr. Shea is recommending significant intervention for that for Mr. Gondek, and I think that plays in. But I think under this court's case law, regardless, a prior accurate medical history is important, and that's citrus pest control for this court. So, as I said, there's the two-pronged test under 440-105. I believe that the first one is an objective and evaluation. And the JCC here erred because he played into the subjective intent prong into the first prong of this analysis. And so I'll take them in turn. We have 3 different areas. First, the hypertension. Mr. Gondek testified that he was not diagnosed with hypertension and that he was only taking medication for about a month-ish, quote, before the accident. Well, that's contradicted by evidence in the record, blatant evidence in the record. There's pharmacy records, there's diagnoses, there's testimony from his treating doctor, all that he was diagnosed with hypertension, as well as that he was taking this medication, lisinopril, losartan, things like that, as early as 2014. And now, the JCC specifically determined that because the claimant testified that he was taking Adderall, which is not corroborated by any medical evidence in the record, that his subjective belief that he did not have these diagnoses was, I guess, a substitute for the fact that he did not make a misrepresentation. But that doesn't explain that he was taking the medication, why he testified that he only was taking it for a month-ish before the accident. That maybe plays into the subjective intent for the purposes of the misrepresentation made as to the diagnosis. It doesn't play into why he was taking this medicine from 2014 on, and that it's throughout his medical records and his pharmacy records. I mean, it's all throughout this record.
Didn't the carrier have access to all that information? I mean, this claim has been They've been processing this claim since, what, 2017?
Sure, so the misrepresentations didn't occur until his deposition, that was later.
Right. So, I mean, but the employer and the carrier, or the servicing agent, whoever's processing the adjuster, has access in a lot of these medical records. Probably, didn't the adjuster have access to all that information? Most of that information previously, was aware one way or the other of what his treatment plan was or what his history was?
Your Honor, it's my understanding that it was difficult to obtain these records, and I actually think they only go back to 2014 because the PCP was unable to get, or they changed their programming or something like that where they couldn't get it as far back, and I believe that there was a dispute as to whether the records were able to be subpoenaed or received. So I'm not sure how long the carrier, and I don't think the record necessarily reflects how long the carrier actually had the records in their possession, but I think that there's inconsistencies in what Mr. Gondek was reporting to his doctors throughout this, throughout the life of the claim.
440, 105, 4B, dealing with misrepresentation, unlawful for a person to, and then a variety of things, but all of them seem to have knowingly in front of them. So when the JCC finds that any misrepresentation or any false statement that the claimant made was not knowing, isn't that, CSE for the finding such that we can't touch that?
Your Honor, I don't think it's CSE here because I think that the JCC1 failed to even recognize that there was a misrepresentation. And so I think that the JCC did not necessarily get to the intent analysis for a lot of these misrepresentations. And I think this is illustrated by the fact that maybe there, I mean, if this court were to construe the self-serving testimony of Mr. Gondek.
I mean, all testimony, if I'm a plaintiff in a case, my testimony is going to be self-serving. I'm not going to typically put on the defense case, right? So,
sure.
Yeah, and you'll make that argument, but that doesn't seem like your strongest argument there, that it's self-serving. It's still CSE if the JCC believes it, right?
I understand. Yes, Your Honor, I can understand that, but I don't think that that he did not think he was diagnosed with hypertension or erectile dysfunction explains why he testified that he was only taking this medicine a month-ish before the accident for the hypertension, and as the JCC found, there was a misrepresentation in regards to the medicine being taken for the erectile dysfunction. But I also think that at times, while the JCC's credibility determinations are typically gospel in a sense, there's still times that there has to be constraints on that. And I think that this record shows that simply because Mr. Gondek believed that he had these as a side effect of Adderall, which he never complained of to his PCP, or at least that's not reflected in the medical records, that in and of itself, that the statement alone of his self-serving testimony is not CSE, because it has to be supported, as a reasonable inference. And the reasonable inference here is, I think that it's a strained interpretation to reach that.
Is the statute designed to, this sounds more like a discovery sanction, almost like if it were in a civil litigation context. Okay, the plaintiff gets caught in a lie or some sort of misrepresentation during deposition, and then you put them on the stand during the trial, and that's impeachment evidence. It just seems odd to then have this develop like within discovery in the case to give rise to an affirmative defense, which is almost extrinsic or intrinsic to the case as opposed to something that happened previously or in connection with the actual claim. Or to put it differently, the statute seems to read more to get at employees that, let's say they don't tell the truth about the facts of the injury or the facts of the accident, and that's misleading to get compensation. Okay, now that's an affirmative defense. Here, it seems like the employer's trying to play, after processing the claim, accepting it for quite a while, does a deposition and almost plays gotcha to get out of the claim. Is that what the statute is for? Is to provide a remedy for, being misleading during a deposition, for instance?
Your Honor, I think that was a policy decision that the legislature made to say even a misrepresentation can lead to this. And so I think that, yes, that this is something that the statute is geared towards. And I understand that maybe it feels unfair, but that's the legislature's decision to do that. And we're stuck with what the legislature said in that regard.
On both the obesity and the hypertension, there's evidence that even if he had that pre-existing, it got substantially worse. I mean, like a whole lot more weight, 180 over something for blood pressure, terrible high blood pressure. So even if he had that pre-existing, how would that be material when there seems to be record evidence to support that he's got a need for treatment for both of those conditions?
I think that it's material because he's seeking to continue to maintain these benefits that he's receiving, and by telling his doctors things that are not true in regards to the previous or pre-existing conditions. And I also think that there's, and this kind of plays into the third issue in the briefing, that there's no evidence about MCC. I think that there's nothing in the record that says this is more than 51%, the accident was more than 51% of the cause of the need for additional medication, weight loss, the hypertension, all of things like that. I certainly agree with Your Honor that, yes, it's reflected in the record that he gained a lot of weight and that there was higher blood pressure readings. I don't disagree with
Didn't
that.
Dr. Shea seem to say that that's what led to the need for the GLP-1?
And Dr. Shea, I agree that Dr. Shea did say that, but I think that there's that alone, that medical testimony is not necessarily saying that it's more than 51% of the cause. I think that that's almost the magic language in this regard. And I see I'm into my rebuttal time if the court has no more questions.
Thank you. Weiner.
Good morning again, Your Honors. May it please the court, Mike Weiner here on behalf of the appellee claimant, Mr. Gondek. Your Honors, we are here asking you to affirm the opinion or order of the judge of compensation claims for several reasons. Number one, because it was the judge's job to conduct a final hearing, to receive the evidence, to review that evidence, and then to evaluate the credibility and candor and demeanor of witnesses, and most importantly, to make the ultimate resolution of intent, which is exactly what he did, and he did it properly here. Number two, because the carrier bore the burden of proof on their affirmative defense of fraud, and they simply failed to meet it. We need to dispossess ourselves of the notion that the appellants put forward in their brief that the claimant needed to prove this or needed to prove that. He didn't need to prove anything with regard to the carrier's misrepresentation defense. He could sit there silently and do nothing and just let the carrier not prove it, which is frankly what happened. But he did provide evidence. And even despite that, and comes from the Mitchell Communications case, that the decision in favor of a party without the burden of proof need not be supported by competent substantial evidence. But the claimant still did come forth with evidence that was competent and substantial that supported the fact that he did not knowingly, and I think Judge Bilber, you made a very important point here, that those false statements have to be knowingly made, and I think the carrier glosses over this in their briefs. They just say any false statement. Well, that doesn't tell the whole story. They cite to the Howard case for saying any false statement, but a false statement has to be knowingly made, and then it has to be made with the requisite subjective intent, which the carrier must prove that he did it because he wanted to get a workers' comp benefit or because he thought it would have a material impact on his case. And the judge looked at the credibility. He did what this court cannot do, right? He looked at the claimants into his eyes. He listened to the inflections in his voice. He looked at his gestures. Was he covering his mouth? Was he fidgeting? Was he sweating? All these things. None of these things this court, as a reviewing court, has the opportunity to do.
Is there at some point where a JCC doesn't recognize that there are manifest untruths that are given that should tip into our analysis of the knowing part?
What the claimant knew is a subjective inquiry that has to be determined by the judge of compensation claims, right? This court, I would submit to you, as a reviewing court, I pointed this out, I think, in our notice of supplemental authority in the referencing the Wall case, which I wish I would have put it in my brief and I overlooked it, but I think it pretty much is the penultimate exposition of what is the role of the JCC versus what is the role of this court, right? Especially when it comes to live witness testimony in front of the JCC, which we have that here from the claimant and from the claimant's wife, which the judge evaluated. And then he also looks at it and says, well, how does this all square up with all this surveillance video that I'm seeing, right? The carrier had hours and hours of surveillance video. And so the judge takes all this in. He resolves all of these conflicts, which is what his role and his duty is. And then he makes the requisite findings of intent. And what this court said in Wall was that under our deferential standard of review, we make a legal assessment as to whether someone reasonably could reach the conclusion that the JCC reached about a certain facts when faced with the evidence submitted, right? And I would humbly submit to you.
So whether a JCC mischaracterized objectively something as an untruth, a half-truth, or, misleading or something like that, that other side of the equation sort of stands on its own.
Well, I would say some things can be black and white, right? Certainly. But when we are attempting to pervade into the claimant's subjective intent of what he knew and whether what he knew he was consciously misrepresenting in an effort to secure some form of workers' compensation benefit, that exclusively belongs to the JCC, right? We don't, and that's what we have here. We don't have a sort of a black and white issue. And I really would take issue with some of the statements. I don't feel as if some of the statements I heard today and some of the statements that are contained in the brief are really a fair and accurate representation of really what is contained in the record. We heard today that the claimant repeatedly denied that he had any that he had ever taken any hypertension medication up until a month before his accident. That's not true at all. He was asked about this. He admitted to taking hypertension medication through Gretchen. That's at page 1595 of the record. He then admitted that he took hypertension medication since 2013 that was prescribed by Gretchen, and he apologized for his confusion as to the dates because, as he said it, my memory is bad. Okay, that's at page 1599 of the record. So the claimant fully disclosed in his deposition that what the appellants have done is try to take certain things out of context here, right?
Well, but that's why, I was asking your opposing counsel this question. That's why this whole posture doesn't make sense to me. Like when I read 440.09.4a, it talks about not being entitled to compensation or benefits if any JCC or ALJ, court or jury determines, that the employee knowingly or intentionally engaged in any of the acts described. So why would jury be mentioned in that? Why would a court be mentioned in that statute unless it is cross-referencing some extrinsic events? And then if there's a determination that something that the employee did wrong outside the case, then that could be a basis for terminating benefits. But to go through this process, they file a PFB, and then there's a deposition taken, and then it's like, aha, we got your client, because he said one thing here, and then he says another thing on the stand, or he says one thing in depo, but now we have the medical records, and we've caught him. And so now we have an affirmative defense, and to heck with all the other things we were going to assert, now we've got the brass ring, or the golden ticket on this. That doesn't strike me as the way the statute's supposed to be.
Well, I would agree with your interpretation of it, Your Honor. I would hazard a guess that the reference to jury is because sometimes this issue can be brought forth in a criminal setting, and that's probably why the
That's
legislature.
exactly right.
Right.
Or in a civil case,
Right, or in a
separate
civil case,
civil
right.
case where the person's been found to be
And I
violent.
think there's sort of a gotcha attempt that's being used here, both in terms of legislatively trying to gain the system as part of what the appellants have done here, as well as in terms of a lot of their statements lacking context, right? If you say one thing here, but you later clarify or explain it later, right, that doesn't mean that this thing that you said here, that you can only hang on to A as a basis for misrepresentation. We have, in this case, is in every case, and this is a 3,000-page record, right? Of course we're going to have conflicting evidence. Of course there are going to be things that, conflicts the judge will have to resolve. And then we've got a gentleman here who, let's look at the claimant, right? Tragically injured. Dr. Shea calls him among the worst injured of any, the highest level of injury you could possibly have. He's got autism. He's got ADHD. Now he's got all these other issues going on. He's got these urinary issues. He's incontinent in his bowel, and he defecates himself. He's had a back surgery. He's got, had a spinal cord stimulator. He subsequently is diagnosed with complex regional pain syndrome. He's seen all these litany of different doctors. And so is he going to maybe make a mistake about who he saw or when he took something? Yes.
6 or 7 years earlier.
Especially all those years ago, right? And that's why context matters so much. And that's why the judge has the right to look at him and say, man, I can understand how he might get this wrong, given all that he's been through. And not be knowingly lying about it or not knowingly lying about it for the purpose of securing a workers' comp benefit, which is exactly what the judge of compensation claims did in this case, right? He resolved those issues as to intent.
Can I jump you ahead to the second issue
Yes.
that they've raised on the prescription? I had cited a minute ago Chapter 465 on the pharmacy chapter, which has a detailed definition of prescription, which is what we would typically think of a prescription. You go to the doctor and, okay, you got high blood pressure, here's your prescription, go get, whatever meds to treat that. Why is that not the appropriate definition of prescription for us to use, as opposed to saying an IME equals a prescription?
Yeah, it's a good question, Your Honor, and I'm glad that you asked it, and I was hoping to get to it. If the legislature wanted to confine the definition of prescription to as it is in Chapter 651, or give it some other definition, they could have done so. They didn't do that in the context of workers' compensation. I would submit to you that a prescription should be given its ordinary, plain language, dictionary definition, right? What is a prescription? It's something in writing that makes a recommendation for a certain type of care, okay? What the carrier has done here is they're exalting form over substance. They're trying to say that because, and by the way, the most nefarious part of their argument is that what they're saying is that an IME doctor cannot recommend attendant care because he can't prescribe a prescription for it because he's not a treating doctor. We agree, an IME doctor is not a treating doctor. But to
And they're brought into a case for a specific purpose, to write up a report, to evaluate and write up a report. They're not there to treat, or I doubt this IME took on Mr. Gonick as a patient. So the direction and control, I mean, it's all sort of wraps in there together that this is it seems to be a very limited scope function of what an IME is serving here.
Precisely. An IME does an independent assessment, and then he makes recommendations. The statute seems very clear that an IME doctor cannot provide treatment unless the parties so agree, right? Not an issue here. You did reference, Judge Tannenbaum, and I want to get to...
An IME is also not authorized unless there's a dispute over, one of the listed things. So where's the dispute here?
You beat me to it. Okay, so this was not briefed by the parties, and if I get the case name wrong, I apologize. I believe it's Cortina. In the Cortina case, discuss the issues where you can arise to a dispute. One of the basis upon which a dispute can be created if the claimant goes to an authorized treating doctor, receives a diagnosis or recommendations for treatment, and he disagrees with that, the claimant is saying, I disagree with that. That is a dispute. That is a dispute that lets the claimant get an IME. So in this case, the claimant...
How is that a dispute regarding medical benefits under this chapter?
This is what your honors have said
Well, I know,
in the
but I'm just
Cortina.
I'm making the
Well,
mistake of looking at the
yeah,
statute.
I guess the easiest way to say is that, at some point, Mr. Gondek and his wife said, you know what, we don't agree with the fact that no one has looked at this attendant care issue, right? None of these treating doctors have looked at it. And so we disagree with the refusal of the doctors to address the issue of attendant care. I think I need more than what these doctors are recommending. Ergo, a dispute exists, right? The dispute is a really low threshold.
But the
And I would say-
doctor's not recommending something. It's an authorized provider that's treating your client. I
Right.
mean, they're providing treatment. They're
Right,
not
but-
operating within the context of a disputed claim. They're just providing treatment.
They're
And your
provi-
client didn't like what the provider, the course of treatment. Why not seek a one-time change instead?
Well, that would be another way that you could go about doing it.
Well, it's statutorily provided for.
It's
I mean, that
allowed
is
for, but
happening.
it doesn't mean that
But
you
not the
can't.
IME.
But it doesn't mean that you can't get an IME for that, right? Because all you have to have is a dispute. A dispute is nothing more than a disagreement. So when the claimant shows up at Dr. Rodriguez's office, I think was the last physician who saw him, and he says, you're good to go, I got nothing else for you. The claimant's free to say, I disagree with that. I have a dispute as to that. And the statute says, and has always said, and it's always been interpreted that way by this court, that you can get an IME to resolve that dispute. You don't have to have...
Between the claimant and his physician?
Yeah, that's the way it's been interpreted in the Cortina case. And again, listen, candidly, neither of the parties have briefed this, so I'm
And then
kind
is
of
the JCC
extemporaneously
supposed to
speaking
come-
on this matter.
Is the
so-
JCC supposed to come in and then resolve the dispute between the physician and the IME?
Yes, sir.
Is the employer a party to this, or do you just bring in who is the respondent in that petition?
Well, the carrier did in fact respond to it, and they contested it, and they got their own IME to dispute the dispute that had been created. And this is the way the system has always worked, and I would submit to you that it was designed to work, right? Because the carrier gets to control everything, right? They get to pick all the authorized treating doctors who the claimant will get to see throughout the life of the claim. The claimant has really very little by way of agency in his case. He can ask for a one-time change, but as this court is well aware, if the carrier responds in 5 days, they're going to pick somebody else he gets to see. So the claimant has to have some sort of an out that when he says, okay, I really don't like the doctors the opinions of the doctors that you gave me. I don't agree with their opinions. That creates a dispute. The dispute gives rise to the entitlement to an IME.
I just don't see how that's an opinion. When the doctor is treating your client and comes up with a course of treatment, which has been authorized by the carrier, and the statute allows, if you don't like what that physician is doing, you can seek a change. This seems to circumvent that whole process and allow you a second bite.
That's always the way that the IME provision under
Yeah,
section
but then here we are.
440.13
Now
has
you
been
have
interpreted.
But here we are now. Now you have an IME that's not, that is doing a report, and then that counts as a prescription.
Of course it does, because it
It
is
just
a
seems
written
very-
recommendation for treatment.
Assuming we agree with you on this unpreserved issue on the IME, the IME doctor can't treat, so why can he prescribe?
Well, again, I would tell you that we cannot exalt form over substance, and that when we are to interpret the provisions of Chapter 440, we have a direct legislative intent as to how we are to interpret them, right? And that is to furnish benefits to the injured worker in an efficient manner, right? And so closing the courthouse doors to injured workers who have a medical necessity by virtue of the judge's determination on their merits to attendant care is not honoring that legislative mandate, not at all.
I mean, I assume that if we had some case somewhere where we said IME equals prescribed, that you would have provided that, right? So you're not aware of any cases out there? where
I don't think this issue that the carrier has raised in this case has ever been raised before. I certainly haven't seen it. Quite frankly, I find it a tenuous reading at the statute, to put it kindly.
Well, who is the physician that's providing the direction and control over this attendant care? Who is that?
Well, it was Dr. Shea who ordered what was reasonable and medically necessary, and who
Is there
provided a
follow-up
recommendation
appointment?
for
I mean,
care.
There's not treatment here, or there's no follow-up. I mean, where does the direction and control, address direction and control for me? What does that mean?
Well, first of all,
I get the written prescription part. That's a separate part of the statute.
yes,
Direction and control, where does that come from?
I would submit that at this point, it would be incumbent upon the carrier, given the judge's finding that attendant care is medically necessary, to then authorize a treating provider who
So
can
it
continue to
becomes-
provide that.
So direction and control is a future thing.
Yeah. I mean, look, I cannot escape from the unassailable fact that an IME cannot provide treatment. That's what the statute says. But by the same token, the statute has to be read in context with the whole text, right? And the whole text canon is important here. Why? Because section 440.13 subparagraph 5 tells us that an IME opinion is admissible in any dispute, right? The legislature didn't give a carve-out for attendant care, right? This court has held in prior cases that even in EMA, look, an expert medical advisor, right, is not providing direction and control, but an expert medical advisor can be called upon by the judge of compensation claims to provide the ultimate answer as to whether or not a claimant should receive attendant care or not, right?
So that gets back to, I mean, I know it wasn't directly argued, but you can't get away from what I think is the misuse of the IME. The dispute that you're talking about, that you just mentioned as being admissible, is a dispute between the authorized physician and the IME that you sought, not a dispute with the authorized physician and the carrier. And so it still doesn't make any sense. But are you also able to address the weight gain
Yeah, I mean, look, I think this is a pure competent substantial evidence issue. I've cited the evidence in our brief in the statement of facts. Claimant was, and I'm just going to use ballpark numbers here, 270 pounds before. He balloons up to about 330 pounds after. Dr. Shea testifies that is a direct result of his having, been inactive, unable to move, unable to work, unable to function, right? He testifies that the Mounjaro or the GLP-1s are reasonable and medically necessary, and that the work injury is the major contributing cause for all of his recommendations. So again, I take issue with the carrier's assertion that there's no evidence as to major contributing cause. I think that's complete nonsense. Dr. Shea was very clear in his deposition that the injury was the major contributing cause for the weight loss, for the need for the attendant care, and for everything else that he had prescribed.
Wasn't he, he was obese.
That's okay, and that's okay, right?
Before the accident?
You could be obese before, and you could still need it as a result of the accident, especially given the context of, the significant limitations that his injury places upon him, as well as the fact that he had significant additional weight gain beyond that. Now, there could be an argument at some point that the carrier got him back to baseline, and that's all they were supposed to do, but that's really an argument for a different day. Your Honors, we're here asking you to affirm the decision of the judge of compensation claims in all respects. It was supported by competent substantial evidence. Insofar as the misrepresentation defense is concerned, the judge did his duty of resolving the conflicts in the evidence and making, as this court has held as his responsibility over and over again, the requisite findings of intent. He did not find that the claimant intended to make any false statements knowingly, and also for the purpose of securing workers' compensation benefits. And your role as the appellate court, as outlined in the Wall case, is to affirm that decision, because that decision is one which reasonable persons could come to that same conclusion. And we thank you for your time.
Thank you, Mr. Weiner.
Your Honors, I've heard a lot of allegations this morning about nefarious intent or misrepresenting things in the briefs and things like that, and I would just encourage the court to look at the record cites that are in the brief. And specifically on page 1596 of the record, which is Mr. Gondek's deposition, he says, it's asked, how long were you taking medication for high blood pressure or hypertension before the accident? He says, I want to say probably a month-ish. And then later it's asked, so it was shortly before the accident you were taking this medicine? He says, I would say yes. Okay, that is what is in the record, that is what it is, and I would just say that the record speaks for itself in that regard. Now, in regards to the misrepresentation, actually, the breaking down the two prongs, I think that the first prong is an objective prong, and it's a determination for the JCC to look at the records and say, well, was there a misrepresentation here? And I think that comports with the text of the statute, and I think that comports with the legislature's intent behind this statute. And now, Judge Tannenbaum, to your question about impeachment and the ability to use this later on, again, I think that the legislature made a decision to say that it's an oral or written statement, and when that happens, that's when the domino effect comes in. And I think that the legislature chose to do that, and they chose to use those words, and this court has interpreted as much that it has to be a specific statement. And I think that, or oral or written statement, or cause someone to have it, all the statutory text in the
I mean, what the legislature said was, if a JCC determines that there, it fits within one of the provisions of 44105, then there's no entitlement to benefits. And then we have a situation here where the JCC didn't determine that. And that's why, I asked the question earlier that it doesn't make sense that this would be an affirmative defense, as opposed to if something happened within the proceeding and the JCC happened to determine that there's some misleading statement along the way, that would give rise to a basis, then the employer could say, okay, we're yanking benefits now. But to use the statute as a got you, as almost like a discovery sanction, which seems to be what it's being used as here, is he made what you consider or what your client considers to be misrepresentation in the deposition, and now that gives rise to an affirmative defense. And I just don't understand how that works under the statute.
And unfortunately, I don't think we can write things into the statutes or rewrite them in a way that would be more helpful in that regard. And I know that sometimes that might be tempting, but the court is not supposed to do that in this case. And I also want to address one more thing in regards to the dispute about the prescription. Mrs. Gondek testified that they never asked the doctors about attendant care. So how can there be a dispute if they were never asked about that specific need for attendant care? In addition, I just want to make sure that the court understands there's no argument about admissibility in regards to the IME doctors. That was never briefed, that was never brought up in our brief, that was something that the other side brought up in their answer brief, and there was no argument about that admissibility. It's an argument about the text, context, in this court's case law of interpreting that section. And if your honors have no further questions.
Well, what about the CSE for weight? Obviously the claimant asserts that, well, even though, he was obese before, but that doesn't necessarily mean that he's not entitled to weight loss treatment now. That sounds like an evidentiary dispute at that point, which we can't really resolve.
I would just say that there's no competent substantial evidence to support the actual determination that there was a 51% or more, the accident was the 51% or more cause of the need for the weight loss medication, especially when he was being recommended for weight loss for years before the accident.
Right, but that's burdens of proof and weighing the evidence is a fact finder's responsibility. That we can't sit here necessarily and look at the record and start making those calculations. I don't know, was it 50, but I know that MCC that's a separate definition, but how do we assess on the record whether there's actually enough evidence? If you have a health provider that's saying that it was, that this is all related to the original accident, the JCC made a determination, you're saying that none of that counts because it's so obvious that he was obese before, so we should just ignore all the evidence that the JCC was looking at and just go with.
No, Your Honor, I don't think you should ignore evidence, and I understand this court is not a court that reweighs evidence, and that's not the point here. The point here is that there's not that specific testimony about that cause, the causal relationship, and I don't read Dr. Shea's report or his opinions as doing that. Thank you, Your Honors.
Thank you, Ms. Sills. Thanks, both of you. All right, our second case this morning is case number 23-1229, Larry J. Bean versus State of Florida. Mr. Rufferman, whenever you're ready.
Thank you. Good morning. May it please the court. Michael Lefferman on behalf of the appellant Larry Bean, and I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this morning on the first claim raised in the briefs, and then of course I'm prepared to answer any questions that the court has regarding the remaining claims. The first claim concerns whether the trial court erred by denying the motion for new trial after it was established that juror Kuhn was not truthful on the juror questionnaire. So after the trial in this case, there was an investigation that was conducted, and the investigation and the subsequent juror interview of juror Kuhn established that juror Kuhn did not answer the following question truthfully. On the juror questionnaire it says, have you or any member of your family ever been accused, complainant, or witness in a criminal case? And juror Kuhn checked no on that form. It was later established both in the investigation and then during the June 4th, 2024 interview that juror Kuhn had a son who had previously been trespassed from her property. Juror Kuhn had the father of that son who had been arrested for DUI in 1997. Juror Kuhn had a father of another son who she said, quote, had 2 DUIs in Florida and a couple more in Wisconsin. And then Juror Kuhn was shown a police report from May 18th, 2017 from the Walton County Sheriff's Office that established that the Juror Kuhn's son had a father who lived out of state because he was an alcoholic.
And I'm going to call it the De La Rosa test because that's the Supreme Court case.
Yes.
That the Mitchell case
Yes,
cited.
correct, Your Honor.
Right on. Is it a strict liability type of thing? So if what you're doing now, you're just, okay, she answered no on the questionnaire, and then you got all this documentation that is contrary to that answer, is that the end of the inquiry for that particular prong? Or does there need to be more? Like, the standard talks about conceal. So does that require there to be more of a showing than just there's a conflict between the answer and the facts? Does she have to clearly remember all of that and then knowingly not answer correctly on the questionnaire? Or is the inquiry just what you're doing right now?
I think, well, maybe 2 answers to that. I don't think you're asking about materiality. Materiality obviously is the first prong of the test. As far as, the case law is clear that it doesn't have to be intentional. So we don't have to establish that she perhaps intentionally withheld this information. I think we have to establish.
It could be accidentally concealed.
Correct. That is true.
Is that possible? Can someone accidentally conceal something?
I don't know. I don't think there's any indication that that's what happened here. When she was questioned during the jury interview by me, she acknowledged all of these facts. She didn't say that I didn't remember them back then. This has just come to my attention now, or I just now remembering this. She gave no explanation as to why she didn't answer truthfully on the form, but yet she acknowledged that she had all of these family members that have had significant issues with alcohol. Many of the men in her lives had criminal history based on alcohol-related incidents. So I don't know how to answer your question, Your Honor, other than, at least in this case, there is no claim that she didn't remember at the time. I think that could be a closer case when you're looking at the case law that says it doesn't need to be intentional. It could be accidental. But here, there's no indication that it was accidental. Every indication was when she's asked about it, yeah, she acknowledges this is my family history.
Can I ask you about the third prong then of the De La Rosa test?
Of course.
The due diligence, and I know you were retained after the trial. It's appointed counsel, so we're not talking trial of the century with jury consultants and such there at the trial level. Nonetheless, there's some time after jury selection. It's a few days later before the trial. So if this is going to be an issue, was there not a requirement for then appointed counsel to do some kind of rudimentary record search at least to see if any of the 6 jurors and how many of our alternates had any kind of misrepresentations at that point?
I think that's the state has raised that. I've had this issue come up in other cases around the state, and that's been discussed. I think that's perhaps an interesting policy consideration about maybe changing the rule, but counsel's entitled to rely upon 3.575. And 3.575 now says that juror misconduct issues must be raised within 10 days following the verdict. Now, obviously, our case is a little different because we have the good cause exception that was met. But any reasonable defense attorney relying upon that rule would not believe that there was any requirement to have to do this in the middle of the trial, and there is this time period up until 10 days following the verdict. Now, could there be a really great discussion within the Criminal Procedure Rules Committee about whether or not this is something that should be done earlier? Sure, and I would love to engage in that discussion as well. I think the one side of it is defense counsel, especially as you've already indicated, this is not the case of the century. We're talking, single counsel. There's not a defense team. Defense counsel is focused on moving forward with the trial. once that jury is selected. They're not focused on, do I need to spend extra time going home at night and trying to track down a juror investigator to do this type of work. But more importantly, again, defense counsel wouldn't be led to believe that that's something that needed to be done because the rule as currently written allows for that 10 days after the verdict.
If I agree with you on that, what about the materiality of the false statement? A correction officer served, which seems a little odd to me that you'd put a correction officer on a jury, but not you, but the trial counsel would. But a correction officer served, a juror who was arrested and claimed that he had been treated unfairly by law enforcement had served. So these misdemeanor offenses that had occurred 5+ years before trial, how do we analyze whether those were materials for the De La Rosa test?
I can go through each and every one of the jurors that potentially are question marks in this case, and let me do that very quickly. Mr. Rochelle is one of the jurors you referred to. Mr. Rochelle said two things. He said, number one, that he did have a prior arrest, but when asked about that by the prosecutor, he ultimately stated that he didn't feel that he was treated fairly by law enforcement. That's potentially something that defense counsel strategically would say, I want that juror, because this juror has a bad view of law enforcement. Mr. Rochelle also later said that he knew someone who had been a victim of sexual abuse. But ultimately, Mr. Rochelle was chosen as the alternate, was not one of the 6 that served in this case, did not render the verdict. But again, I can explain why defense counsel would leave Mr. Rochelle on and not strike him as the alternate, because he gave a very favorable answer from the defense standpoint that he did not have a good experience regarding his arrest relating to law enforcement. He thought he was treated unfairly. There was 4 other jurors, Miss Rodriguez, Mr. Matthews, Miss Bird, and Miss Windhorst. They were asked just about the facts of the case. Could you be fair after hearing just what the charges were? All of them said no. Every one of them was stricken for cause. Both parties agree, and the judge agreed as well. Mr. Miller, he said that he does not drink. The state says in their answer brief that, defense counsel didn't use a peremptory challenge on Mr. Miller. Defense counsel wasn't even given that opportunity. If you look at jury selection, as soon as the judge ended the cause challenges, any more cause challenges? No. Okay, state, peremptory challenges to you, and immediately the state is the one that strikes Mr. Miller. For all I know, defense counsel would have. Defense counsel wasn't even given that opportunity. The state struck Mr. Miller before the judge even asked defense counsel about peremptory challenges. Ms. Dykes is the only other one that answered that she does not drink. We don't know. Ms. Dykes was never in the 6. For all we know, defense counsel would have stricken Ms. Dykes had she had the opportunity to. There was 2 other jurors that said that they know of people who drink excessively. Unfortunately, in this transcript, I think this is on page 50, is there anybody else that has a friend or family or close relative that drinks in excess? Prospective juror, yes. Prospective juror, I do. The transcript of our jury selection only refers to our jurors as prospective jurors. We only know their names if the party asking the question then followed up and said Ms. Dykes, Mr. Windhorst, whatever it might be. For all we know, those 2 prospective jurors were 2 of the prospective jurors that had already previously mentioned that they couldn't serve on this case, so there was no reason to follow up because there was already going to be a cause challenge that subsequently was granted. So I submit that there's nothing in this jury selection transcript that indicates that defense counsel was in any way deficient or failed to follow up on issues relating to alcohol. There's no juror who sat on this case that had any issue with alcohol. And therefore, again, when you look at alcohol being such a key issue in this case, I think the trial court, when discussing the 3rd issue in our case, whether to give the voluntary intox instruction, specifically said, this is page 394 of the trial transcripts, the trial court calculated there were between 9 and 14 beers consumed by my client on the date of the incident. When after the incident, when there's body cam, when my client's being questioned by the family, my client is completely out of it. My client's statements were, I don't remember any of this. Alcohol is a key issue in this case. I submit that any reasonable defense attorney would not want Juror Kuhn to be on this case. It doesn't mean there's anything wrong with Juror Kuhn. She may be a perfect juror for another case. But in a case where alcohol is a central issue, and you have a juror who it seems like every man, including her sons in her life, has had problems with alcohol, that's what any reasonable defense attorney would say, she's just not an appropriate juror for this
How
case.
far back do we go in looking at the materiality? So say she had made a false statement, her father had a DUI in the 60s, that she had forgotten about, or maybe she even fraudulently conceals it. At some point, that's not going to be material. You would
I agree.
So how do we balance that, or is that something that the trial court balances?
Well, it's a great question, and let me just quickly address the second part first. Trial court didn't balance any of this. I think the state concedes that when they recommend that this be sent back. The trial court did not address any of these factors and I attempted to. The trial court said, what about the 3 factors? I would address the 3 factors, and the trial court never said anything. But I think a couple things with materiality. I do think the standard has to be materiality. The courts say if defense counsel had known, would reasonable defense counsel have exercised a peremptory challenge? Not a cause challenge, doesn't rise to that level, but just a peremptory challenge. I do think it's a reasonableness standard. Now, I will note that I proffered in the record when this case came up, and there was a question about whether or not I was asking for the judge to find good cause. I was asking for the judge to find that we'd met a prima facie case under the 3 factors. And I said I had both Ms. Peterson available and also had Ms. Gooden, the trial attorney, available. And I proffered, and this is on page 442 of the record, I proffered that Ms. Gooden would have said that she, in fact, would have stricken this juror had she known about Juror Kuhn's past. And the judge kind of moved right through and said, State, we don't need to deal with this. You agreed that the juror should be interviewed, and the state agreed. So there was no further discussion about any of that. But I'm not saying that just because Ms. Gooden said that she would have stricken the juror, that all of a sudden that means I meet materiality. I think it's an objective test. So I think the court has to look at it objectively. If you had if you had the only issue with alcohol for a particular juror going back 30 or 40 years, well, that's a much weaker case for me to be able to say, oh, no reasonable attorney would have failed to have used a peremptory challenge on that juror had they known. But when you look at the extensive impact that alcohol has had on Juror Kuhn's life, with not only at least 2 fathers of her children, one the police report referring to as an alcoholic who lives in another state, she acknowledging that one of them had 2 DUIs in Florida and others in Wisconsin, another one having DUI arrests back in Florida back in 1997, and then her own sons. The date of this incident, her son came home, grabbed a bottle of rum, drank it, and then became aggressive and started biting her current partner and threatened to kill both her and her partner. Clearly, alcohol has had an impact in Juror Kuhn's life. And therefore, I submit that, it's not a situation that you have just one incident from 40 years ago with a grandfather. You have, it seems like, every man in her life having this major impact with alcohol, and therefore no reasonable attorney, Ms. Gooden included as was proffered, would not have stricken her had she been truthful on her jury questionnaire. I believe that all 3 factors were met. I believe there was nothing else that Ms. Gooden needed to do during jury selection. Attorneys have a right to rely upon these answers. This is why we have the jury questionnaire. It can't be that that every attorney would have to get up and say, okay, on your jury questionnaire, you answered yes to this question. Is that correct? You answered no to this question. Is that correct? That would defeat the purpose of juror questionnaires. So when she said no, I've never had anyone in my family been accused of a crime, and I've never been a complainant or witness to any type of crime. And we now know that was patently false. Ms. Gooden had a right to rely upon it. There was no point in doing any follow-up. She said no. And I think it was material. I think it would have resulted in a peremptory challenge. I think it's established under the second factor that it was clearly false. And I think that this requires my client to get a new trial. He was misled. We rely upon jury selection. Some lawyers would say it's the most important part of the case, that you know whether you've won or you've lost based on the jurors that you've picked. We rely upon jurors to be truthful in the jury selection process. That's the only way it can work. So again, it's not that these jurors are right, or have done something wrong or improper. It's just, are they the right fit for this particular case? This juror withheld something that made it so defense counsel couldn't make that decision. And again, I submit that any reasonable attorney, had they known her true past, would have used a peremptory challenge, and that would have resulted in her not being on this jury. And that's the standard. We meet the 3 prongs, and therefore my client should get a new trial with a fair jury. Thank you. I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Effer. Ms. Townsend.
Good morning. May it please the court, Darcy Townsend on behalf of the state of Florida, the appellee. This case really is about due diligence, and on Monday, the jury was chosen. On Friday, the trial commenced, and 3 days later, on Monday, appellant went out and hired, or his family hired, this covert ops team, which isn't even a private investigator, actually. Per her report, they are using public records searches that are ubiquitously available online now. A lot has changed since the De La Rosa case in 1995, when that information might be much harder to come by. But in the 3 days between trial and jury selection, there was plenty of time to comb through social media or do a rudimentary background.
And what would have
search.
happened, let's say the investigation that was done after the trial were done in these 3 days that you're focusing on. Walk through, what would the procedural outcome have been at that point?
Well, I disagree
What
with
would have
Mr. Offerman that any attorney would
No.
strike
Like,
this
the jury was
person.
selected on a Monday,
Mm-hmm.
and then the trial is later in the week, and you're focusing on, I'm assuming your argument is, well, they could have done the thing they did after the trial in the intervening 3 days between jury selection and the trial.
And if they were concerned about it, they could.
And then what would have happened, so if they brought the same information that they discovered from this investigating company after the trial to the court's attention in those 3 days, I guess, or I don't know how long it takes, but, you know, you're focusing on that, and the due diligence should have been, they should have been doing this investigation right before trial.
Yes, Your Honor.
And my question is, well, then what would have happened? Okay, we discovered this juror, the questionnaire is not accurate. So then what? What would have happened?
They have an opportunity to bring it before the court's attention and
And
ask
then
for the
what?
alternate, or move to strike the panel and pick another jury. But they didn't do that in this case. They could have brought it to the court's attention and tried to, or interviewed the juror even during,
So the
before
real
trial.
argument
but-
here is just well, because everyone's gone through the inconvenience of having this trial, so now the defendant should be barred. Because the result would have been you were not going to have that trial on that day. You're going to have to
No.
redo everything.
Not
in
necessarily.
theory.
They also could have decided to proceed with this juror on the panel. We don't know, because they didn't conduct this search. We don't know that she would have struck this juror, that it would have been material information. Mr. Efferman didn't call her, or call the defense attorney at the hearing, and he can't say that that the information was so egregious that every reasonable attorney would have.
I
would
guess
have
what I'm
struck
really
her.
asking is the due diligence component of the test really designed to say, well, you know, yes, you did find that there was some false or inaccurate statements on this, and we know that, let's say it did make a difference, but we don't, it's too late. Sorry, you did it 2 days, like if you'd done it the week before, it would have been fine, but you waited till a week later to do it, and regardless of what the facts are, that doesn't count as due diligence. Because we know you could have done it, this investigation, but you just didn't do it early enough. Like, should they have postponed the trial? Let's say the investigation, they hired that company, and the company was going to take like a week to do it. So are they supposed to ask for the trial to not go forward until that investigation's done?
Well, if they were concerned about this, they could have asked for something.
Well, maybe it's a
They could've.
routine thing that they do in every case. I mean, what's to say? You seem to be like taking what they did after the fact and projecting it back, well, they should have done it earlier, and that counts as a failure to do due diligence.
Well, they could have done it earlier if they were concerned about exposing juror bias or misconduct. They could have looked into it, and the failure to do so is lack of due diligence.
So no defendant should ever, after they're convicted, should hire an investigation company to see if jurors were untruthful, because it shouldn't matter, because, well, if you were willing to hire them after the fact, you should have hired them before the fact.
Well, it's a Hail Mary. It's a type of, I would submit it's a type of sandbagging. You're keeping this in your hip pocket instead of this was a really
Well, what are
broad
they keeping in
question.
their hip pocket? No one knows if the jurors are being untruthful at the front end. Everyone assumes that the jurors are being truthful. That's the whole point. Otherwise, why put them under oath? Why
Well-
call it voir dire?
They're also asking broad questions. We hope the jurors are being truthful, but it's also, you ask vague questions, you're going to get vague responses. We acknowledge that there are going to be misunderstandings. They're not always going to understand the call of the question, that it's
But that's a different
difficult
problem.
to get people to talk. There's some people that, I'm sorry, Your Honor.
No, but that's a different prong. Now you're talking about materiality, whether it was actually concealment, those kinds of things. But on the due diligence side, and we can move on, that's fine.
I
But-
think they go hand in hand, too.
Well, Mr. Ufferman points out the rule that currently allows 10 days after rendition of the verdict to move for the jury interview. So that would, he says, seem to imply that you've got some time after the verdict to look into any problems that you might have with the jury. What's your response to that?
He didn't show good cause. That's going to open, this issue is popping up more and more, so if we allow for 10 days every time somebody goes out and hires a private investigator, there's not going to be, and that automatically gives you good cause for however long it took them to dig up this information and go fishing for something that the juror may or may not have disclosed. That's going to destroy the finality of verdicts.
Well, I mean, I agree,
in every case.
if resources were no object, if this was some multimillionaire on trial for this, he would have had a team there, he would have had a couple of attorneys, he would have had a jury consultant, he might have had a couple of jury consultants advising him, they would have screened, I mean, you've seen the, what's the movie,
Runaway Jury.
Grisham, Runaway Jury, yeah, Grisham movie and the book on the jury consultants. I mean, that was 30 years ago that they were doing stuff like that. But your person with an appointed counsel is not typically able to do that during trial, and Jack is certainly not going to pay for that during trial, right? So, what do you do?
Well, these are pretty simple searches. Even people looking into background checks for tenants or somebody going before they go on a date, there are public record searches that are available immediately and online that they can do. The trial counsel could have had an assistant running or Googling these jurors. They certainly had the time between trial and jury selection to search for these.
So, I mean, are you saying that the due diligence imposes an obligation on trial counsel to disbelieve what the jury told you during voir dire?
If you're concerned about exposing bias, you need to make an attempt to do it before trial, or if you're worried that something didn't come out in voir dire, there are resources available to check that, and lawyers routinely do.
Have you ever been to trial?
Yes, Your Honor.
As counsel, solo? As a solo practitioner?
Yes, I was prosecutor.
So, well, but I mean, as a solo practitioner, have you ever been to trial?
No.
So the idea of a solo practitioner who has jury selection on one day, presumably has multiple clients that they have to tend to, maybe even multiple trials that day. They may be selecting multiple juries that day. And the due diligence standard should be, well, every lawyer who is curious or concerned, or just as a matter of practice, they're going to do an investigation on their own. Instead of getting ready for trial, they're going to hit the internet after jury selection that day and look through every juror that's been selected to see if there is some inaccuracy in the questionnaire answers. Is that the suggestion? That's the standard of due diligence?
If you are concerned about That, and not every attorney is. Some want to pick the first 6 people that are awake and alert during jury selection, but if you're wanting to make sure and not wait until after the fact then you need to exercise due diligence beforehand.
But in this case, that wasn't the lawyer that did it, it was the family who wanted to do it, right?
It's not clear how the record doesn't say, they say the family hired him. That could have been at the suggestion of the lawyer. The fact that this is popping up all over the state would suggest that
Maybe there's a
There-
new company out there that's marketing this to defendants.
Or
But
defense
Let's just
counsel.
say, instead of this being a formal investigation, 2 days after the trial, there's someone happens to know the juror, and they kind of like surreptitiously say, hey, just kind of like a whistleblower, hey, you may want to look into this juror. I happen to know that she was at the bar yesterday and was chatting about how she didn't disclose all the information. You should look into it. And then they go and search and find it. Is the standard the same? They say, well, but had you done a social media search the day of jury selection, you would have found that same information, so you're out of luck on it. Is that the standard?
No, in that situation, that is that hypothetical doesn't allow for that is information that they could not have known without due diligence, but what is turned up in this case is information that was available rather than somebody bragging at a bar that came to light a different way.
And the state's hip pocket concern is basically, no one's going to do this before they have a verdict because they might win, right? Then they won't need to do it. So they keep this
Yeah.
in their hip pocket, then later they're going to go do this because, hey, that's a second bite. So that's the
Exactly.
state's countervailing concern.
Exactly, Your Honor.
How do we deal with, if we disagree with you on the diligence part, and we say, well, the rule says 10 days, so this was diligent, or, it's something like Judge Tannenbaum's hypothetical where not even a search, somebody just out of the blue, this information is revealed within 10 days. How do we deal with whether it's material or not, then, a different prong under the De La Rosa?
Well, it still has to, I believe one of the cases I cited talked about, it has to expose an inherent bias in front of the juror. Even at the evidentiary hearing, there was no showing that, while Mr. Efron says that alcohol ravaged her life and affected most of the men in her family, her answers at the evidentiary hearing really don't indicate that. And that she acknowledged that her husband's had had DUI arrests. It was attenuated. It was years ago. There was no further questioning even at the jury interview about how that affected her, if there was no exposure of any bias.
I thought the test was material to jury service. Didn't the Supreme Court later, like in Roberts v. Tejada, reference it's material to the juror's service? Because if you're talking about whether they're biased, now you're into a harmless error analysis, which I don't see mentioned in any of the Supreme Court's discussion about this area. Disagree?
It would still have to be relevant to the jury service in this case, and I believe the cases say on a case-by-case basis that there's not going to be a per se error, and it has to be evaluated. I would disagree with Mr. Efferman. I think the judge here did evaluate when he said this was an indiscrepancy. It doesn't go to whether or not she had any sort of bias was exposed against hearing this type of case.
Well, but then if you're going to go down the bias road, so then you're saying that whenever the judge asks, or let's say Denver voir dire, and it's a standard question, it's like, okay, but can you be unbiased? Can you put aside whatever bias or whatever and judge this case fairly in a balanced way, whatever? That would obviate any subsequent juror challenge if they answer, yes, I can be unbiased. Otherwise, how do you calculate that or process that or analyze it if if bias is the question, they've already, so you have a juror that's potentially not been truthful in a questionnaire after they've been put under oath, but then they answer under oath that they can be unbiased, and then later you find out, well, they answered a question incorrectly or untruthfully on the questionnaire, but is it material to whether they're whether there would be biased on the jury?
Going to the particular facts of the case, it wasn't shown in this case that this is her ex-husband's and deceased ex-husband's DUIs. It didn't reveal she didn't show any animosity to.
Well, no one could ask that because they didn't know that that was actually a fact.
Well, they had that opportunity. Mr. Efferman had that opportunity to show the material, that it was material. He had the opportunity at the evidentiary hearing, and at voir dire, the trial attorney did ask widely about alcohol, but didn't follow up on questions with when the entire jury panel answered yes to knowing some people that drink to excess. She didn't seem concerned with. She didn't follow up with other questions or individual jurors.
So this would be a
So-
different case if at voir dire or if Mr. Rufferman would have asked, followed up with, okay, you've had this experience with alcohol. Does that bias you one way or the other? I mean, do we have that in the record? Like, which way would that cut? I mean, we now have learned that she has experience with alcohol in her family, but we don't know which way that cuts. It could cut either way, and that would show bias to the extent that it cuts one of those ways.
Correct, Your
Do
Honor.
we have that in the record that there's a bias associated with?
We don't have that it wasn't shown in this record to show that it was material it needed to be to expose that was not established in the evidentiary hearing.
Could I ask you about the concealed prong? My understanding of the cases is consistent with what Mr. Efferman said, that you can inadvertently conceal something, which seems weird to me. Is that, what's your response to that?
Not every concealment has to be intentional, but this isn't, but it does have to go to the jury service, and it doesn't, and you can't be, it has to be a direct response to the question that was asked here. It was a vague question, because what is a family? What is, anybody in a jury pool could answer that question differently, could misunderstand that you're talking about ex-husbands or second cousins. And there is an element of having to know that it's responsive to the question.
Familiar with the line of cases? I think there's Busby and Matanzas and a bunch of it talking about peremptory challenges, and if there's a trial judge fails to properly strike a juror for good cause, and the whole song and dance you have to go through to preserve it and then raise it on appeal. I'm assuming you're familiar with that whole line. Now, what do you think why does the Supreme Court put so much emphasis on the importance of peremptory? So the harm there is that they've been deprived of peremptory that they could have had to exercise somewhere else. Why do you think that the Supreme Court has said that that's harmful to the defendant?
Because they have a right to, they can help choose their jury and make an informed decision on who they want in this jury,
Right.
but
Because that's going to contribute to a fair trial. That's been established for a very long time, that integrated with the right to have a jury is the right to, participate in the selection of your jury so that it's perceived to be fair and that the defendant has participated in that and perceives that trial to be fair, right?
Yes, but there was one of the cases cited in my brief where one of the jurors had been out of the room it was a civil case, but when the parties had agreed to, the juror inadvertently concealed information, remembered it after the fact. Unlike in other cases, it came up during trial. The party itself did not want to have that juror on, but in that case, the court found the trial court didn't abuse its discretion by still keeping that juror on. That you can exercise that right, but it also has limits.
Thank you, Ms. Townsend.
May it please the court, there's a couple points I want to make. The first point, Your Honor, regarding the concern about an attorney keeping it in this type of issue in the hip pocket and then bringing it up later. I think actual knowledge matters in that context, and that's this court's Belcher opinion that was cited by the state in its answer brief. In Belcher, the court found that the attorney was aware and then failed to timely file, and in that situation, you're out of luck. So clearly, if defense counsel knew or should have known about juror misconduct during the trial and then failed to bring it up, I think that's always considered a waiver. In this case, there's no indication that Ms. Gooden had any idea that Juror Kuhn had engaged in juror misconduct. It wasn't until the family, as was mentioned in the 3.575 motion, retained Ms. Peterson that this became an issue. Second, after Juror Kuhn acknowledged that everything that was contained in Ms. Peterson's report during the juror interview was true, and that she did, in fact, have all of these family members who's had issues with alcohol, there was nothing further to follow up on. Whether or not she believed that she was biased as a result of that, that's not the standard for determining whether or not a defendant should be given relief in one of these situations. That's the standard that applies in post-conviction. If you bring up one of these challenges after direct appeal is over and in post-conviction, the Florida Supreme Court recently clarified that the only way you can win in that type of situation is if you can show that an actually biased juror sat on the case. That is not the standard for a 3.575 motion. You simply have to show
Does
that
it roll under the relevancy or the materiality portion of De La Rosa?
It is, well, it's material, but it's material. Here's the difference. I think in the post-conviction context, where the Supreme Court recently decided, you'd have to show that the juror would be subject to a cause challenge. But at this stage of the proceedings, you'd only have to show that the defense attorney would have used a peremptory challenge. And obviously, a defense attorney can use a peremptory challenge for any reason other than an unconstitutional reason. So in a case like this, that's, as I've argued, and it's already been established that that's what Ms. Gooden believed as well, if you'd have known that this juror had not just an uncle from 30 years ago, but extensive involvement with men in her life that had alcohol-related issues, no reasonable attorney, in light of the facts of this case, 9 to 14 beers, would want to keep that juror on this case. Number three, and I've already addressed this, number four, I do want to point out that, and this is page 442 of the record, when we had this hearing, the second hearing in the case, I was at that hearing prepared to make arguments about why the good cause standard was met and to show that we made a prima facie showing under the three prongs under De La Rosa. I said, and this quote, Ms. Gooden is here, and I would proffer that she would say that had she known the truth about this juror's background, she certainly would have used a peremptory challenge on this juror. And then the judge interjects and says, any objection to talking to the juror? And he's asking that question to the state. And the state responds, ultimately, no, Your Honor, I agree. We should have the juror interview. Any questions or concerns that the state had about the good cause standard, any questions that they had about due diligence, all of those would have needed to be raised by the state right then. The state would have needed to say, yes, Your Honor, I do object. I think Mr. Ufferman hasn't met his burden. I think the due diligence is an issue here. But no, when directly asked by the judge, any objection to talking to the juror, the prosecutor agrees that yes, and that's why the juror interview was scheduled.
Well, but I mean, the due diligence to conduct the interview differs from the due diligence that counsel should have done to discover the issue in the first place, right? I mean, those are two different things. And there's no dispute, the trial counsel was out of the country for a wedding.
Correct.
So that, I don't have any problem with that not being a lack of due diligence. But that's a different question than the due diligence as far as whether this should or shouldn't have been discovered before the trial commenced.
And I think we've had this discussion. I'll rely upon the answers I've given. I think this would be a healthy discussion for the Criminal Procedure Rules Committee as to should the rule be changed to require this type of investigation to be conducted in the middle of the trial, but there's no case that says that right now. So for all the reasons I've argued.
Can I just,
Of course.
before you sit down, just one quick, going from big to small. So on the cost issue 4, if the trial judge pronounces whatever, fines and costs, whatever, and asks counsel any problem or any objection, and trial counsel says no, is that a forfeiture of the issue for later? I say forfeiture, some would call it waiver, but such that you can't raise it in a subsequent.
I think it's, a couple answers, and I apologize if you allow me to answer and give these two answers. I think there's clearly a waiver if, and I was just in a sentencing hearing yesterday and I observed this, if the judge says, defense counsel, do you agree, do you waive me individually reading the cost and fines? And if defense counsel says yes, that's the end of the issue. It cannot be raised thereafter because defense counsel agreed for the trial court to engage in that procedure. Otherwise, though, this court and every court in the state and the Florida Supreme Court has said that this is a notice issue. And if the trial court's going to impose these discretionary fines, the judge has the obligation to do it. So defense counsel there may not realize, and therefore simply saying I don't object without understanding that that's the law, that's not a waiver of the issue. That's not the same as the trial judge specifically saying, do you agree to me not individualizing the fines and cost? So therefore, I don't think simply saying I don't object waives the issue. And again, the court has put the burden on trial attorneys, trial courts to provide this notice. And I ask this court to continue to stick with its precedent in that regard. To sum up, I don't think these were little indiscrepancies. I think this affected my client's ability to be able to pick a fair jury, and therefore I'd ask this court to reverse. Thank you.
Thank you, Mr. Offerman. Thanks, both of you. That concludes our oral argument session this morning. We are adjourned.
All rise.
Good seeing everyone. Thank you. You guys have a good day. And we'll see you, Charles. Thanks,